Hello, everyone. I'm Kevin Gosztola. I'm the managing editor for Shadowproof, also the curator of the Dissenter newsletter. And welcome to this live broadcast. I'll be going over why former President Donald Trump, is unlikely to be charged under the Espionage Act. And this brings in a history of the Justice Department using the law, bringing it against people who are found guilty of mishandling classified information or who have improperly handled classified information. The Espionage Act is very much a part of the two-tiered justice system in the United States. And by that, I mean not that the Justice Department only goes after Republicans. I don't mean that they only go after people of one set of political beliefs. Although when you look at history, there is a segment of people who have been repressed more than other groups. But I mean that lower class individuals, lower income people, those who are lower level government employees and contractors are the ones that get charged with violating the Espionage Act. Not Donald Trump, not former high-ranking officials with influence or power like Donald Trump. And so I'll play a clip of a former Justice Department official who was on the Skullduggery podcast on Yahoo News. I'll play a few clips of her. This is a person who I think has added to the conventional wisdom that it's a possibility that Donald Trump could be charged without discussing the reality that I just expressed here, that I think needs to be part of the conversation, and why the limitations of going after Donald Trump would be confined to the Presidential Records Act, which we all know so much more about than we ever really did need to know after this past week's search of Trump's home at Mar-a-Lago. Welcome. This is the Shadowproof YouTube channel. If you're here for the first time, I encourage you to subscribe to this channel. I encourage you to, get set so that you are notified of alerts when we do go live. I cover whistleblower stories. I cover the case against Julian Assange, who is being prosecuted under the Espionage Act. But in this conversation, that is not something that comes up when talking about the potential of Donald Trump to be charged under the Espionage Act. And then obviously there have been many whistleblowers who were charged under the Espionage Act. And I recognize, just from the top here, I recognize that there are families of people who were punished. There are friends of people who were punished, supporters of people who blew the whistle, and they were prosecuted under the Espionage Act. One of these individuals is still in prison, is serving a prison sentence. And there are people who are still on probation. There's one person who's still on probation. One person has been marooned in Russia and cannot come home. So you have Terry Albury, Daniel Hale, Reality Winner, and you have the fact that Julian Assange is being prosecuted. You have Thomas Drake, who was prosecuted. John Kiriakou was prosecuted. Chelsea Manning was prosecuted. Of course, Edward Snowden is in Russia. And all these people who went to the press with information rather than trying to keep it in their private possession are better individuals than any of the people who will come up in this broadcast today. They recognize that not only is information in the public interest, but there's an urgency sometimes to this information, demands that it gets out to the people. So I say that at the top because what I'm talking about are a universe of mishandling of classified information cases that are not related to going to the press. The people who I named today took the information. They were accused of having it in their homes, and they were using it for their own personal reasons. And then It's not like we were going to benefit from it at all collectively. And this seems to be what was going on with Donald Trump. So just to set this all up here before we get too far into it, as I understand what has happened with Donald Trump, as I understand it, let me set this all up here. There was a raid by FBI agents that people at the Justice Department really don't want you to call a raid, but there were numerous FBI agents that deployed and entered his Mar-a-Lago home. And in his property, they went to his safe and they took documents that were there. The reports that we are reading say that 10, maybe 12 boxes of documents were recovered by the federal agents. Those boxes are now part of an investigation that has been unfolding for several months, goes all the way back to at least 2021, although the Justice Department was not involved yet. What we know is that the National Archives was in communication with Donald Trump and his representatives. Probably not Donald Trump. Trump's representatives were working with the archives to recover documents that the archives found were missing from the presidential records that were turned over to them. And so at a certain point, there were people who went to Mar-a-Lago, and this was in January 2022, and they found 15 boxes. They brought back 15 boxes of materials. Those materials had classified information. So that was the first time they went to Mar-a-Lago. And those materials with classified information, it meant that the National Archives had to notify the Justice Department. The Justice Department now knows that there is classified information, possibly more of it in Donald Trump's possession. And so they conduct an investigation because they take this all very seriously. I followed the whistleblower cases, and I've also looked at insider threat training materials. This is sacrosanct. This type of thing is, it's for them. It's like it's like the Catholic Church enforcing the production code against Hollywood in the early 1900s. They take this very, very seriously, and they treat it like an issue of morality, that you're not supposed to violate classified information from the U.S. government. It is that insane. And so Donald Trump now is facing legal jeopardy. And we also know that back in May, June, sometimes in the spring, the date hasn't exactly been nailed down in news reporting, but there were Justice Department officials, including possibly a counterintelligence chief, someone involved in litigation, that went to Mar-a-Lago and wanted to account for the location of documents. And at that point, these boxes that were just retrieved in the raid were not given to him. I have no idea what that means for Donald Trump, but I will note that there's a section of the Espionage Act that can implicate you if you fail to hand over materials to an officer because you aren't supposed to have them in your possession. Donald Trump, he no longer is supposed to possess classified information. Those records go to, I can't believe I'm saying this word, but his library. And like all presidents, he will have to have a library, even if he's not one to read books. That should be available for scholars. So all of these records that were in the possession of his property, or him, that he had some plan or no plan to do anything with. We don't know what he was imagining he would do with these records, but those records are supposed to be part of the archives. And I understand that there are records in presidential archives that the CIA, the NSA, other intelligence agencies often will exact authority over so that we never know truths about what happened under particular presidents. They can delay the release, invoking uh, very dubious national security excuses. But still, if he has it, then we're never going to get it. So there is a public interest in reclaiming those public records and making sure the National Archives has them to prepare for a presidential library, for um, their distribution in the National Archives. And so I'll play for you this clip first. I want to set this up. So this is Mary McCord, who's a former Justice Department chief of police, who's involved in a leadership position at the National Security Division under President Barack Obama. And you can hear her describe. She'll describe to you why she thinks that the Espionage Act could be applied to Donald Trump.
But there's another potential crime here that has to do with classified information, and the fact that we have national security division lawyers such as Jay Brett, the head of counterintelligence and export control, does mean that we're talking about national security implications, not simply presidential records that aren't classified. And I know that's already been reported. It's about classified documents, but I just want to, be clear that, it's a violation to take even non-classified information violates that 2071. Another potential crime is actually under the Espionage Act, which is 18 USC 793. And that actually has provisions that apply to essentially the mishandling through gross negligence, permitting documents to be removed from their proper place or to be lost, stolen, or destroyed. And there's also conspiracy provisions within that 18 USC 793. So, that again, gross negligence would be a different standard of intent than the willfulness for 2071. But certainly gross negligence could be proved by willfulness, because that would be even beyond gross negligence.
All right. So typically what happens in these cases under the Espionage Act is that the Justice Department is making a choice to go after individuals as if they are spies, or to use this law in a manner that is extraordinarily harsh. Because what we're going to learn with Donald Trump are the different laws that are on the books for the U.S. government to make sure that there is some penalty to people who take classified information when they're not supposed to do that. Not all of them necessarily are going to get the sledgehammer of the Espionage Act, but some of them will, because of the fact that they do not have the ability to negotiate with people who are in high places, that they don't have the ability to use their status and use their team of lawyers. Donald Trump has a team of lawyers. And then most people who you look at who have been charged with what Mary is talking about, it is true, all of those things, taking, losing, using them for your own personal purposes, those have been charged. There are at least a dozen or so cases. I went through them over at the Dissenter. So if you go over to the dissenter.org, I put together a report on this before doing this video that looked at why the Justice Department was unlikely to charge Donald Trump. And in making that case, I went through some of these other individuals to show that, in particular, these people who do get charged are those who are working as contractors for the NSA or CIA. They are lower level government employees. They may be older. They could be career people who have been at these agencies for some time, but they're not political appointees, and they aren't anyone who is in leadership positions. The same dynamic that is at play when you see someone like Reality Winner or Daniel Hale or others prosecuted is at play in this instance. Whereas there are high-ranking officials who can go to the press and they don't have to worry about prosecution under the Espionage Act. The same goes for taking, stealing, using classified information for your own personal benefit, whatever you would like to do with that information. A few of the examples that I give in this report relate to the fact that there's cases like, for example, well, let's just take this one. This is a recent one in 2021. It involves a 48-year-old FBI intelligence analyst who was someone who was found to be keeping in their home in Dodge City, Kansas, documents on FBI counterterrorism operations, and as well as CIA documents on Al-Qaeda operations in Africa. And so, maybe all of that information could be potentially valuable if we were to learn about it. It could open up an important conversation, but this person was keeping that information in their home and it just was in their possession. And much like Donald Trump, they had some plan for it later on down the line. But this person had been taking this information between June 2004 and December 2017 for over a decade. So obviously that raised questions about security, information security back during that era, which we know it was poor since Chelsea Manning was able to make her submissions to WikiLeaks and take that information from the various secret information database. But that's another conversation. There's someone like CIA contractor Ronaldo Regis. In 2018, he was found to be copying classified information to personal notebooks. There were about 60 notebooks that were retrieved by FBI agents when those agents raided his home in Maryland. And then, these are the kinds of people that have faced punishment. They're nobodies, but the people who were career officers or had careers as contractors working at these intelligence or security agencies. You look then at a very odd case, but one that I think is an example of how the Espionage Act can be applied. So if you believe that somebody isn't really trying to injure the U.S. by taking this information or trying to advantage a foreign power, which is what it says under the Espionage Act, then, maybe you might point to this example as one for why Donald Trump could be charged. There was James Hitzelberger in 2012. Secrecy News, which used to be this great resource for following this particular genre of cases, especially news related to classified information, security, etc. He was in Bahrain. That's where he was stationed. And he wound up charged with violating the Espionage Act because he had this habit of taking classified documents back to his living quarters. That's right. He just thought it was good reading, and he'd go kick back in his living quarters in Bahrain on this Navy installation and read about special operations, read about, drone strikes, read about all this stuff. Just, I guess, out of sheer fascination for what the national security state is capable of doing globally. And he was reading these documents. The FBI found classified documents in his possession. They prosecuted him. This person also had a collection of documents at the Hoover Institution at Stanford University. And there were documents from these secret databases on terrorism operations, counterterrorism operations that I presume were being put into files in what was called the James Hitzelberger collection at the Hoover Institution. And Hoover Institution had to basically ban James Hitzelberger from giving future files, donating future files to this collection or keeping them in this collection. And the FBI did go and retrieve these documents from the Hoover Institution. There's no malice there, but it is for his own personal benefit that he's taking this information. And certainly, I suppose it's a benefit if you know that that information is at the Hoover Institution. Scholars can go look at it. But, these materials are not for your own personal reading. And so he was prosecuted for it. And you can see that there is a possible basis for charging Donald Trump. But the problem is that he's a former U.S. president. So he's not going to be prosecuted under the law. But someone who might be prosecuted under the law or should have been prosecuted under the Espionage Act is David Petraeus. And David Petraeus was a CIA director. David Petraeus was the Secretary of Defense for the Pentagon. He was in a position of great power. And what we know about David Petraeus is that he was able to use his position in 2015 to get the Justice Department to not charge him as a felon. So in other words, someone like Petraeus, and I think Trump is on the same level, gets the ability to persuade Justice Department officials that they should not become convicted felons. That's a luxury that most people don't have. None of these cases that I mentioned or document and recount in the Dissenter newsletter, none of those people were able to persuade the Justice Department to give them lesser charges. To say, I really didn't mean any harm. Don't put this on my record that I violated the Espionage Act. So Petraeus was able to get this down to being a violation of the criminal code that just applies to public agency employees. And it said that he possessed documents and materials with classified information. He unlawfully and knowingly removed the documents without authority, and he had the intent to retain, keep them in his possession. Those documents and materials, they were at unauthorized locations. He was aware those locations were not places where he could store and retain those classified documents, and yet he did. And it gets, it gets even better because what they accuse him of doing involves these black books. It includes these 5 by 8-inch notebooks that contained his schedule and classified and unclassified notes, which David Petraeus took during official meetings, conferences, and briefings. I'm reading from the fact sheet for David Petraeus when he pled guilty to the charge. That was a misdemeanor. That meant that he wasn't going to be a felon. That meant he could continue to be a warmonger. That meant that he would have no impact to his career. And he did owe a fine, but he was able to do a speaking engagement, let's say 2 or 3 of those speaking engagements. And then he was we recouped all the money that he had lost paying the Justice Department this fine, which would be essentially someone like Petraeus. That fine becomes the equivalent of a traffic violation because it's not hard to get that money back People want to hear what you have to say about making war around the globe and asserting U.S. global dominance. So, and he's been on TV a lot with the war in Ukraine. So David Petraeus took these notebooks. They were black books. He taped his business card on the front exterior of each notebook. And there's 8 of them. And they were part of the command, I believe, that was fighting wars in the Middle East and Afghanistan. They contained classified information on, there were identities of covert officers, war strategy, intelligence capabilities and mechanisms, diplomatic discussions, quotes and deliberative discussions from high-level National Security Council meetings, and notes from his meetings with President Barack Obama. These black books contained top secret and code word information, some of the most highly classified information that you can find in the U.S. government. And so what does David Petraeus do? Well, David Petraeus was stooping his biographer, Paula Broadwell. He had an affair with her, and David Petraeus was willing to give his lover, someone he was really into, access to all these files. And she got her hands on these black books and was able to use them for reference while she developed this lionizing book about Petraeus called All In, The Education of General David Petraeus. I believe that's the subtitle. And that was what happened. And yet, despite this, David Petraeus still was not convicted or charged with violating the Espionage Act, even though he technically did what all of these other cases I mentioned, those people did. He actually did worse, I would argue. And yet he was able to use his status to avoid being prosecuted under the Espionage Act. And that's something missing from the conversation from these individuals like Mary McCord. But I have some more clips of her speaking. I have some of these clips to play before I wind this down. So here's another clip of Mary describing the dynamic of Trump and whether he would be charged with violating the Espionage Act.
Yeah. When you were the head of the National Security Division, what would it have taken? What sort of evidence would you have wanted to see before you would have signed off on a search warrant of a potential suspect, indictee? What would it have taken to convince you that you ought to do that?
So always for a search warrant, you need probable cause that evidence of a crime will be found at the location sought to be searched, right? So I think what you're really asking is not, what would I have taken in terms of probable cause, but what prudential concerns would go into it, particularly in a sensitive case like this where we're talking about a former president. And there's also prudential concerns about danger to national security. And is this the right tactic? And an overt search warrant, right? Or is there some other way of mitigating danger to the United States that doesn't involve this kind of overt investigative technique? I would also be thinking down the line, am I going to be able to make a case in court because is the national defense information so sensitive that the equity holder, the National Security Agency whose information it is never going to let me put it in court, is never going to say to me, it's okay, prosecutor, to prove up that this is national defense information, the very nature of which means it would cause substantial damage to U.S. national security if it were disclosed. Admitting that is actually admitting to things that sometimes our national security agencies don't want to admit to. So there's all kinds of prudential things you'd be looking at.
So Mary is talking about the dynamic of charging somebody like President Donald Trump, and there's some more former President Donald Trump, and there's some more that she says, but it's kind of fascinating since she's somebody who is familiar with how these cases have been brought. In fact, I found her name in some of the press releases for a few of these cases. And it's actually not that hard for the Justice Department to pursue the cases without revealing the classified information. And yeah, I suppose there's an issue of confirming the information that it's actually real information in the custody of the US government. But when we're talking about information that the public doesn't know anything about, which is the case when it comes to Donald Trump, there's probably only a handful of individuals that know what that information is. And they're all pretty well recognized as liars and exaggerators. So I don't know why the US government would be afraid, or the Justice Department would be afraid. Yeah, supporters of Trump will probably believe him, but it's going to be hard for us to ever believe any of these people in Trump's circle if they said what they took in those files and made claims about them, especially since they've sat on these files for quite some time now. If they related to anything that was in the public interest and demanded our attention, they would have put it out, gone to journalists with those materials. Instead, it's clear they're just there in Mar-a-Lago, or we're in Mar-a-Lago for Trump's own personal benefit. And so she's talking about the files and how the Justice Department may not want to confirm that this information is, top secret information, or that what was said was real. But I've followed these trials, and you don't know what the person is accused of releasing. The Justice Department negotiates with defense attorneys and the judge, and they come up with a system to very vaguely refer to the information so that you don't really even know what it's about. So, for example, everybody knows that the U.S. is in Afghanistan, but what exactly did somebody leak or disclose without authorization about Afghanistan? Well, the Justice Department would protect the specific information by saying this is document one. Document one is from Afghanistan on July 1st, 2013, and it was maybe from this agency, da da da, and that's it. And that's all you know. And there's no revelation there for us to discuss. There's nothing that I can do with that material. I don't know what that's about. It could mean a lot of things, and it's vague enough that it shows the jury that that was a classified document because it came from a group that was involved in sensitive military or counterintelligence operations. And so that's all the evidence that jury needs in order to determine that the person violated the law, not to mention the pressure that comes for these lower level people to not go to trial, because if they plead, they get shorter sentences, which is the way that 90 to 95% of the two-tiered justice system in the United States works, except it doesn't work like that for Trump. So what the Justice Department is afraid of, and I think it's legitimate, is that if they bring Espionage Act charges against Donald Trump, he's going to take them to trial, and it'll be a circus, something probably on the level of what we saw with the Alex Jones defamation trial, probably even worse. And he's going to bring in some things that are legitimate issues. He's going to bring in some issues that are just silly and absolutely ridiculous. He's going to milk the fact that the FBI targeted him, which he's already doing. And he's going to play to people's senses who know that the FBI has a hideous history in this country. But it's all going to be about himself. And he may be willing to take some of the information and threaten to disclose it from the witness stand to embarrass the U.S. government. So they would never be willing to put people, out there, have representatives of Trump take the stand who would run their mouths and create further risks for the U.S. and its security agencies. For the same reason why they were afraid of what he would do when he was president, they would be afraid of putting him on trial as former president. I think that's another reason, in addition to being a high-ranking official, that Donald Trump is not going to be charged with violating the Espionage Act. They're afraid of Donald Trump. I think that they are afraid of Donald Trump and his supporters. And I believe that to be the case because today, as I do this broadcast, it's been a few days and we still haven't got a statement from the Justice Department that defends what they did and makes it clear that it was not some kind of a political tactic to prevent Donald Trump from running for another election, another shot at the White House, and to be the one who defeats President Joe Biden in 2024, the guy who represents the Republican Party in their challenge against Joe Biden in 2024, presuming that Biden won't retire from politics and will continue to be the octogenarian person he is, who is just very subpar and, not going to stand up to any of the powerful interests, but do their bidding like he has done his entire political career. I think that's the thing that I would focus on more than anything is a dynamic. So there's one more clip. I'll shut this down. Let's play this one.
In terms of a former president, that's what's unprecedented here, to kind of go back to one of the initial questions. And so, it would be more than just, do you have probable cause? It would be, where are we going from here? If we find the things we think we're going to find, are we going to be seeking an indictment from this grand jury? And what are the different things to weigh? Is that, because it's unprecedented, is this in line with other precedents, even though they're not the same? It's not about a former president, but so that would depend on how significant are the documents, right? How sensitive is the national security information? Are we worried that some of this information would actually be shared outside of Mar-a-Lago, potentially with foreign adversaries? I'd be really concerned about that.
And it is the case, by the way, that representatives of foreign governments come to Mar-a-Lago all the time.
That is the case. And it's also the case that the president has said things to foreign adversaries, during his term that caused the intelligence agencies and national security agencies to, become quite alarmed and concerned and startled. But one complication here is that the president, when president, not now, but when president, has the authority to declassify things. He doesn't have that authority anymore.
Okay, so he took all this information. It probably was not properly declassified. I don't really care, though, because the over-classification of information in the entire classified information system is, for the most part, a joke, and in the sense that nobody who is in government can remember what is and is not. But anyways, he's got the actual files in his possession. Something I do find alarming is this story that we know about Donald Trump, and it came in the news reporting after the raid about how he would rip up documents, that he was actually someone who would go around and he would take parts of what is known as the presidential daily briefing. They would just remove pictures from the presidential daily briefing. Because already when he was president, they would give him this very sensitive briefing that is supposed to prepare a president for the day's events. It's got some of the latest intelligence, security, notices, etc., that are in it, details from diplomatic discussions, things that a president should know when doing their daily business. And it had too many words, so they went around and decided that they'll put more pictures in the presidential daily briefing. And so he apparently would rip out these pictures. He posted an Iranian missile site to his Twitter account. So it's like a kid pulling clippings from like their highlights magazine to hang on their wall. It's like somebody who's wants to put up their like sports magazine photos on their wall, except his wall was his Twitter account until he got banned by Twitter. And I mean, these briefings are not newspapers with comic strips for you to just put anywhere. And I spoke to former CIA officer and whistleblower John Kiriakou a couple days ago, shared with me his experience contributing to the presidential daily briefing as someone who had this clearance as a CIA officer, or he might have been doing it as somebody who was part of the Senate Foreign Relations Committee. But in any case, you get read in, you have access for a day to that material, you get to put stuff in the presidential daily briefing. Everyone is very serious about protecting it, so much so that you could have access to reading what you wrote for a day, and then the next day it's blacked out when you get your response back. Like if there's notes from the president about it or notes from anyone in the president's team about something related to the presidential daily briefing, you get the document back. You don't get to see what you wrote, but you get to see the questions or comments about it. And yet Donald Trump's sitting here ripping pages and then taking them with him like your grandpa who is clinging to the past when the newspaper industry wasn't ailing, and you get to like, I guess he's filing them away somewhere. I don't know if they're in his safe at Mar-a-Lago or what, but I just imagine there's a file folder somewhere with clippings from the presidential daily brief. So I don't really even know how the Justice Department begins to account for some of this information. And I know that there are probably journalists who have more stories that they know about than they have shared, and maybe they just didn't know how to corroborate them. But we do know that Maggie Haberman at the New York Times had a story about Donald Trump flushing documents down his toilet. But that was something she chose to keep for her upcoming book in October rather than release it when she immediately learned about it, which is what journalists are supposed to do rather than keep that kind of information so that they can sell books. But that being said, I'm going to wind down this, and I'll just make the essential point again for everyone who made it this far into the broadcast, who made it this far in this video. It's a two-tiered justice system. People like Donald Trump are not going to be prosecuted no matter what people say about him. He's always going to be the former U.S. president, and he has the ability to use his past influence and power. And even if it's not the same as it was when he was in the White House, even if January 6th has besmirched any kind of reputation he might have had as a former president, he still gets to use his power to negotiate and can discourage the Justice Department from prosecuting him with this World War I era law. The people who do get prosecuted are lower class people who do not have the ability to challenge this and do not have the ability to protect themselves. And I'm of the mind that the Espionage Act should be abolished, should be entirely removed. That's not something that people in Congress have any interest in doing. So it sits there on the books, over 100 years old. It gets used against independent journalists that challenge the U.S., like Julian Assange. It gets used against whistleblowers. Then it's there for people who are low-level contractors and employees. They don't get charged with any of the laws that we're talking about as a possibility for Trump, if he is going to even be charged, they get the Espionage Act thrown at them. And then with that, I say that in my view, I have I'm of the mind, and this comes from following the disclosures from WikiLeaks and following what they have promoted, that the public, we all have access to this information. And so we can't have any leader of any country, any former leader of any country, taking documents and putting them in their own safe at their rich, estate, which is this like resort for people from around the world, and keeping it there for their own benefit. It belongs to us. And so I'm no supporter of the FBI, but understand that the materials in those boxes that have been taken never belonged to Donald Trump, and they should not have been at Mar-a-Lago. So with that, I conclude here. Yeah, that's a good point. I'm just going to read a few of these comments before I go forward and sign off. Calibri says Donald Trump might have taken government documents that he could use against his opponents to blackmail people when he tries to take over the government again and maybe dump sensitive information for all to see. That could have been the idea. He might have been looking ahead at the war that he was in with people in these intelligence agencies. There's a battle among the ruling classes in the U.S. Donald Trump's on one side. And then there are people in these national security agencies on the other side. And they clearly are happy with Joe Biden, but they do have to contend with this faction of people that are strident right-wingers who would like the country to go in a much different direction as far as maintaining the project of America. And so he had this information, and we don't know what he was planning to do with it. I'm not sure about the national security risks. I usually find those to be overhyped whenever somebody from the Justice Department talks about them. They tend to talk about the risks in apocalyptic terms. I feel like they're always on the verge of hyperventilating and passing out, and I'm concerned for their health. That being said, he could have used the information to blackmail us. He could have used it to do any number of things. Maybe he had proof of things that have been said about him that are not true. It may have related to the investigation against him, the many investigations against him. He could have been taking that information to protect himself in lawsuits, but that's not what the information is to be used for. And I must insist to you that no matter what you think about the excesses and abuses of the national security state, that it is wrong to allow president to take information and keep it in boxes after he's done. You wouldn't want Joe Biden to take boxes of information. We don't want Obama to take boxes of information. I didn't want George W. Bush or Dick Cheney having boxes of information on the Iraq War that they could keep in their own possession to do with whatever they choose. And so this is something that ultimately, if it ends here, and it probably could end here. It might be that they just wanted to get the information back from Donald Trump. We're all talking about charges. And let's just recognize the very real possibility that nothing happens after this. Because if they were going to do anything after this, I would think that the Justice Department would have come out with a press conference right away when they had the momentum, and they would have said, Donald Trump is being charged with X. We talk about disqualifying him from running because that's something that's part of the Presidential Records Act. I don't think it's as tidy as people are discussing it. You see it in the centrist media, the prestige media, the prestige media talking about how there's a provision the Presidential Records Act. It says that if you do this, you could be disqualified from running for office again. But that requires a trial. It requires going to court. It requires discovery. It requires many hearings. It's costly. The Justice Department has to invest lots of money and resources to take on a former U.S. president, all just to find him guilty of violating the Presidential Records Act. And so I don't know what the plan is from the Justice Department. They haven't really done a good job of letting people know what they're doing and made it clear that it is not the fact that it's not true that they are just trying to discredit Donald Trump so he can't run in 2024. But that being said, as I've mentioned, I do think that information belongs to the people. So thank you everyone for tuning in. I really appreciate it. This is the location that you can go to, thedissenter.org, in which you can find more reporting, including a full report on a lot of what I just said, but maybe some more specific details if you're looking to share information with your friends, family, or colleagues to let them know that, hey, I saw this and I want you to know that I don't think that anything's really going to happen to Donald Trump when it comes to this Espionage Act. If you hear them talking about that, go ahead, send them to the dissenter, show them this report. We're the only site that has this right now. Everyone's, full steam ahead. Justice Department's going to hold Donald Trump accountable. We've got lies upon lies coming from Eric Holder and Lanny Brewer about how they would immediately charge Donald Trump if they were in power today, even though they let off all the Wall Street criminals and they let off the Bush administration criminals who were involved in lying us into the Iraq War, and they committed acts of torture. But all right, that's for another day. Thank you, everyone, for tuning in to this broadcast and video. I'll set chapters so people can get to certain parts of the video after it is archived. And I'll be back soon with another video. Thank you.